Bismillah. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. So for today, our group from Tetuan Anuar and Co will be presenting on the questions regarding the acquisition of orang asli land. So firstly, we will look at the question itself. The question is whether a group of orang asli living in an orang asli reserve may claim compensation upon acquisition of their land by the state authority under the Land Acquisition Act 1960, and if so, on what basis, given the fact that orang asli does not have any document title to evidence their ownership of such lands. So I will pass to the next presenter.
So pertaining to the provision, the general one, we will be looking at Article 13 of Federal Constitution. Under 13.1, stated that no person shall be deprived of property save in accordance with law, and further stated that no law shall provide for the compulsory acquisition or use of property without adequate compensation. For the purpose of our discussion, we're talking about Aboriginal people. We refer to what? Aborigines People Act 1954, where Section 3 provides the classification or definition of Aboriginal people, and Section 6 talks about the Aboriginal areas where the state authority may, by notification in Gazette, declare any area predominantly or exclusively inhabited by Aborigines which has not been declared an Aboriginal reserve under Section 7. Whereby it further illustrated in Section 7 about the Aboriginal reserve, which provides that the state authority may, by notification in Gazette, declare any area exclusively inhabited by Aborigines to be Aboriginal preserve. There are certain requirements that stated under this, and the important one is the state authority may in like manner revoke wholly or in part or vary or any declaration of any Aboriginal reserve made under subsection 1. Then which leads us to the compensation about the acquisition of the land. We may refer to section 12, where stated that if any land exercised from any Aboriginal area or Aboriginal reserve of any right, any Aboriginal area granted had been revoked wholly or partly, the state authority may grant compensation. And section 11 stated that where an Aboriginal community established a claim to fruit or rubber trees on any state which is alienated, granted lease for any purpose, occupied temporarily under license or otherwise disposed of, then such compensation shall be paid to the Aboriginal community as shall appear to the state authority to be just. And subsection 2 provides that any compensation payable under subsection 1 may be paid in accordance with section 12, as I mentioned before. So for that, I'll pass to the next presenter.
So next we move to the cases that had been listed here. Is for the first one is Kerajaan Negeri Selangor and Sagong Bintasi and others, where there is a part of land that had been gazetted by the Orang Asli of Temuan, and which then had been demolished and were taken down because of the highway project that had been proposed by the government, and because of that, the Orang Asli community had filed for to the court, and the court granted the compensation under section 12. And the court held that the precise nature of such customary title depends on the practice and usage of each individual community. And this brings to the second point, which is that the individual practice and usage in regard to the acquisition of customary title is a matter of evidence as the history of each particular community. So now we move to the second case, which is Nor Anak Yawai and others and Borneo Park Plantation, where The plaintiffs were residents of Longhouse, and which then they claimed that the defendant had trespassed and damaged the land. However, the plaintiff did not obtain the community title to the land, and so basically the court held that rights to the land were established by the person who uses and clears the jungle, and practice were passed throughout their descendant, which then that the plaintiff's action and the plaintiff had done, which is included, do not hold any title to the land and may be termed licenses, but their license cannot be terminable at will, since they have their native customary rights, which can only be extinguished in accordance with the law. And this is after the payment of compensation, which is basically in the case of Kerajaan Negeri Selangor. And the last case is Adong bin Kuau and others against Kerajaan Negeri Selangor, where in this case is also included in the Orang Asli community, and which then the court held that regarding uh, the the customary right of Orang Asli, where in Malaysia the Aborigines common law rights include the right to live on their land as their forefathers had lived, and this would mean that even the future generations of the Aboriginal people would be entitled to this right of their forefathers, even though they did not obtain the document title, but since they are the Orasli and they have the native customary rights. So we move to the application and conclusion.
So next I will be talking about the application and conclusion. So looking back at the referred provisions and also the cases, and we also look back at the facts of the case, the Orang Asli do not have any document title to prove their ownership over the land. However, based on the case referred, which is the case of Kerajaan Negeri Selangor, the case of Nur Anak Nyawai and also Adong bin Kuau, it was stated that even though the Orang Asli or the Aborigines people does not have any document title to prove their ownership over the land, they have their customary rights as they are the one who use the said land for generations, as stated in the case of Nur Anak Nyawai, where the case stated that the rights to the land were established by the person who uses and clears the jungle, and the practices were passed throughout their descendants. And therefore, because of this, they have the customary rights over the land. And because of this, the Orang Asli must also prove that they have the customary rights over the land, and also must prove that they are included in the definition of Aboriginal people as stated in Section 3 of the Aboriginal Peoples Act. And because of this, if the state authority wanted to acquire their land, they have the duty to compensate the Orang Asli for the Orang Asli's deprivation over their land being acquired by the state authority. And therefore, if the Orang Asli can prove all this, even without the official document title to prove their ownership over the land, they can still be compensated under Section 11 and 12 of the Aboriginal Peoples Act 1954. All right, so I think that's all for our presentation on the question regarding acquisition of Orang Asli land for today. Thank you, and Assalamualaikum warahmatullahi wabarakatuh.